Welcome back to another edition of Between Two FARs. I'm Warneke Miller, and I've been talking with Brian Stanford about the amazing differences between litigating in front of the GAO and litigating in front of the Court of Federal Claims. Today, we're going to talk about the formalities of these proceedings, as well as the record and other things that you need to think about as you're getting started in your case. Brian, can you just give us an overview about the formality of these different proceedings?
Absolutely. So when you're at the GAO, I think I would characterize the proceeding as more informal insofar as there's no, there's no standard pleading template, no complaint and answer or motion template that you use. It really is kind of up to the agency's discretion, kind of how it puts together its agency report, which has to contain a memorandum of law and a contracting officer statement of facts and record documents, but in terms of what that work product looks like, there's not really any kind of formal formula for doing so. At the GAO, also, the tribunal does not follow the rules of evidence or the rules of civil procedure, and there's no page limit on pleading. So agencies, can protesters can file pleadings that are as long or as short as they want them to be, without any kind of rules on what the page limit actually is. At the Court of Federal Claims, obviously, it's a federal court proceeding, very formalized in the pleadings, in terms of the rules for the pleadings that you are required to file. And they do follow the federal rules of evidence and the federal rules of civil procedure, and the court actually has its own rules. That being said, one go back to GAO, it's a rare occurrence at GAO that you have a hearing, actual in-person or telephonic hearing, where testimony is taken. Our experience has been that the GAO attorney or the hearing examiner that is overseeing that hearing will honor, I will say, analogous standards and precedent with respect to the federal rules of evidence. So objections are on the table and will be credited or not by the hearing examiner. So.
Well, let's talk a little bit about discovery, because we know that's a big one for attorneys. What are the differences between the record that you're compiling and the type of discovery you're doing in these jurisdictions?
Absolutely, it's a huge difference in the depending on where you are. So at GAO, typically our records are limited because the standard at GAO per the rule is relevant records or portions thereof. That portions thereof is very important because oftentimes the agency may say, okay, well, this group of pages is a record. However, only a part of it is relevant to the issues that are being litigated in the protest, and so we're only going to give you that relevant part of that document. And at GAO, the protester has to actually demonstrate why it's entitled to review things like the awardee's proposal, evaluation documents. They have to be very specific in their protest allegations in order to be able to justify the agency putting records into the agency report record. Now, the Court of Federal Claims, it's a much more rigid standard, and that standard is the administrative record by rule is expansive, and it basically can include everything that happened in the procurement, including proposals in their entirety, key evaluation documents, things that an agency might not necessarily produce if not squarely challenged by the protester if they were at GAO. And there's an opportunity when you're at the court for additional discovery and supplementation of the record. So in practice, what we've seen is it's kind of a mixed bag depending on who you're in front of at the GAO in terms of what their tolerance is for agency record withholding. Obviously, the agency needs to make a good faith argument that a particular document isn't relevant to the matter at hand, or the portion of that document is not relevant to the matter at hand. And we've had varying degrees of success, and we've had, I think, compelling arguments for withholding documents credited by certain GAO attorneys. Now, there is a risk if the agency is overly withholding of documents, the GAO can start to, I think, drift towards the presumption that there's no way we can have a full record in this case to actually understand what really happened, which makes it difficult for us to credit the agency's arguments on the merits. So too much withholding can actually harm the merits of a case if you happen to be withholding documents that prevent the GAO from getting the full story of what happened. Now, at the Court of Federal Claims, in practice, again, the government has almost no discretion to kind of curate which documents get included or not. But the big caveat there is, by law, documents that are considered privileged, deliberative process privilege, attorney-client privilege, or attorney work product, are by definition not part of the record. However, the legal standard, especially on deliberative process, I think that's the one that's murkiest for us all. The legal standard is not clear, and the case law is kind of all over the place on what documents that normally might be part of the record would be excluded from the record because they are considered deliberative process privilege. There's a case law standard that concerns whether or not those documents represented a concrete step in the evaluation process, and there's an open question as to whether or not the analyses or opinions of agency officials that maybe weren't part of the core evaluation team that might have been considered by the selection official, whether those go into the record or if they're considered deliberative process. And so it's definitely a mixed bag. We've argued successfully before things like individual evaluator notes don't represent a concrete step in the evaluation process if they were just kind of the agency or the court standard is called like spade work or drafts of the agency's collective deliberative process.
This would be anything before the consensus finding that the individual evaluation. Okay.
Yes, except the case law is not clear on whether or not in certain cases whether those individual evaluator notes take on the quality of becoming a concrete step in the evaluation process or not. So it is again, it's murky territory, and from a practical standpoint, really important because our experience has been DOJ attorneys are, I think, hesitant to wade into withholding certain documents. We oftentimes have a lot of spirited debate with our DOJ counterparts about whether or not a document is privileged or not. Our again, categorically, DOJ attorneys, when in doubt, would prefer to keep records, keep documents in the administrative record. That being said, we've had some very intense side skirmishes with protesters' counsel on deliberative process privilege documents like individual evaluator notes, and we have seen DOJ go to bat for us to be able to prevail on the application of that murky legal standard that certain individual evaluator notes are just not part of the record because they are deliberative process privileged. And then finally, supplementation of the record at COFC. It's a hot topic these days in that forum. So on the GAO side, GAO, the parties, particularly the agency, can put any declaration it wants to into the record, even if that declaration was documented or authored and signed after the procurement closed. But the judges of the court are really kind of permitted to consider information outside the administrative record if it's necessary to permit effective judicial review. So on the one hand, the administrative record is what it is. It's bounded. It may be contested, but we've seen Court of Federal Claims judges taking a lot of discretion to look outside something, to look at evidence that might not strictly be in the record if they feel they need to look at that evidence to render a decision. And so in the end, what is or isn't the administrative record may not be the end all be all of what influences a particular decision at COFC. So.
It definitely sounds like it's a lot of attorney hours and analysis to try to figure out where some of these documents fall. We really
Certainly.
appreciate this overview to help us get started as we wade into our COFC litigation. Would you join us again? I think we need to talk about some of the remedies and some of the other aspects that are differences between these two forums. Y'all just hang in there and come back again and watch us as we wrap up these differences on Between Two FARs.